Good evening, everyone, all the people who are in attendance for this session, and of course, the guests for the evening. For the first time, LEDX is actually having kind of a different format of our webinars. So, we have conducted a lot of webinars and workshops and boot camps for the student community in the past, but this time we are going to have this interactive session on moot court competition. Myself coming from a National Law University background, I have always been very titillated by moot court competitions. It's one of my most favorite activities, as I'm sure most of the students will agree. And as I know, my guest for the evening definitely agrees, given his extensive portfolio with moot court competitions that he has had. So, on that note, I would like to welcome Mr. Chen Sarkar. I will take a moment to give you a brief introduction before we initiate this conversation. So, Mr. Chen Sarkar is the co-founder and partner of Kia LLP, that is KIAA. Mr. Chen Sarkar is one of the founding members and a fifth generation lawyer. He has had the chance of knowing the white, black, and grey sides of the law, an outstanding orator and an expert in insolvency law, criminal law, and other laws pertaining civil and commercial litigation. He regularly appears before the Honorable Supreme Court, High Courts, and other tribunals. Before co-founding Kia LLP, he assisted in the 2G spectrum scam cases. He was instrumental in obtaining ex parte bail orders in the cash coin cryptocurrency scam from the Honorable Supreme Court. He extensively argued before the NCLAD and the Honorable Supreme Court and was successful in bringing unincorporated joint ventures under the purview of IBC, eventually changing the legal position on the said subject matter in the country. Mr. Sarkar successfully argued in writ petitions before the Honorable Supreme Court in which provisions of Section 5 of IBC were under challenge. He is currently appearing for the cryptocurrency scam cases before the Honorable Supreme Court. Besides dealing with Indian laws, he is also adept in dealing with matters pertaining to international law. Sarkar is known for extensively arguing and assisting in a letters regulatory case before the Delhi High Court concerning a mutual legal assistance treaty between India and Russia. He is also a founding member of the global think tank GCTC, that is Global Counterterrorism Council. He has also contributed significantly to legal aid support during the first lockdown of year 2020. In the year 2017, he was awarded with the Alumni Achievers Award by Amity Law School. And in the year 2021, he was recognized and awarded as one of the top 40 lawyers under 40 by the Legal Era Mumbai. It is my absolute pleasure to have you with us this evening, sir. And I'm sure all of our attendees are very excited to hear from you. So, on that note, I would now hand over the mic to you to give us a little introduction about yourself and, of course, about your experience with mooting.
Thank you, Rashmi. A very good evening to the host and the young friends from the legal fraternity. It gives me immense pleasure to be here and getting back to a topic which has always excited me a lot, that is moot courts. Well, as far as my introduction is concerned, I think Rashmi has said a lot about regarding me, and I come from a fifth generation lawyer. I'm a fifth generation lawyer, and I would not say that mooting is in my blood, because there's nothing which is there in your blood. It's something which you have to always develop over the time. And personally, I feel that moot courts has played a very important role in shaping me as a lawyer, because I find, to be very honest, I find moot courts to be much tougher than what we do in courtrooms, because you have 30 minutes and you have the entire problem running down 50 pages, within which time you'll have to completely dissect the problem and present your case. And also the pressure of doing well before an audience and also before the judges, because the main criteria while judging a moot court competition, since I happen to judge a lot of moot courts of late, after passing out from law school in 2011, the main criteria which I always had to face, and I also try to question, try to put the participants into, is asking questions and seeing the ability of the mooter who is facing these barrage of questions, the ability to answer them or to tackle them. It's not always possible for a participant to know the questions, but how to tackle it, how to divert the attention of the court. That is the biggest plus point which we always see. A long time back, one of my seniors, when I had started my profession, he had said that uh, a good lawyer would always present his case well, and when the judge is in his favor, he would definitely present his case well. But the best lawyers are the ones who can divert the attention of the court when he is in a catch 22 situation. So I hope my opponent lawyers are not listening to me on this platform, because in mooting also, I think that's one of the important criterias, because a lot of occasions, there are many occasions when these young mooters who are listening to me right now would be facing situations wherein they are not aware of questions, because international law or national domestic law, they all are very vast. And a judge who is sitting to judge a particular moot court competition, of course, is an experienced man. That person has gone through the grind and the grilling of moot courts. He or she is a practicing lawyer, or maybe in the in-house, working as an in-house counsel. So they would be definitely more aware of the current legal situations, the developments that we have in the courts every day, and they would be asking questions which definitely put the participants in a difficult position. So it is the ability to handle that pressure. I think that's one of the most important things that we tend to learn in moot courts. And now I put over to Rashmi. I think, Rashmi, you can take it forward. I think I've given a brief gist about what mooting is, and then we can take it forward from here.
Absolutely, absolutely. So, all the students that are here, which is currently 100 students in the session, just 1 second.
Right.
I'm so sorry. Yes. So all the
It's okay, no
students who
problem.
are in this session right now with us are absolutely interested in knowing about mooting. And like I said,
Mhm.
I mean, the both of us on the screen right now can attest to the advantages and the benefits that having moot court experience can bring to a person.
Mhm.
So, the way I'm sure there are students from national universities, from private universities, from government colleges, from every kind of institution that are here in this session with us today. So
Mhm.
the first and foremost question that I would say that I would want to ask is that we do know this thing that mooting is a part of curriculum of the Bar Council of India. Like it
Mhm.
is recognized as something that a student should be pursuing actively as part of their curriculum.
Right.
Despite of that, I don't think not every institution is providing that kind of an exposure to
Mhm.
students when it comes to mooting. And I think that's a challenge that most of the students face right now.
Right.
That, okay, fine, if I come from an institute which has a thriving mooting culture, it is much easier for me to get involved into it.
Mhm.
But what about the students who are not coming from those kind of institutions? What would be your advice to them? How can they move forward? And, what exactly are the reasons they should go ahead with it?
Thank you, Rashmi, for the question. The first question itself is very interesting, and that I'll begin the answer of this question with a short anecdote. So I was in Amity Law School at a time when there was the mooting culture was still developing, and we didn't have many senior batches who would be interested too keen on mooting. And I have no qualms in admitting the fact that there was no mooting culture as such, except a very few handful students who would go into moot courts. And also, I do not have any qualms in accepting the fact that we did not have a very active MCA. So initial years, and I was pretty perturbed by the fact that we don't have a mooting culture, because since my school days, I always was into debating and extempores and debates. I used to be a prolific speaker in the school circuit. So I always wanted to enhance my my oratory skills more and more. And moot courts for a law student is probably the best platform. So specifically for the students who do not have a mooting culture in the college, and this answer goes especially for you people. It is for you to decide how to begin. As a student, it is so important to understand what is necessary for or the reason why you are there doing a particular course. Now, once you've identified that, okay, I want to pursue law, I want to become a lawyer, the next thing that you should do is start getting into activities which are associated with law. Books are a lawyer's best friend. We always say this. I would say moot courts are even better friends of a lawyer, if as far as law students are concerned. So what happened with us is there were three people who were extremely interested in mooting, and I would like to take their names. They're very dear friends of mine. One was Mr. Divyanshu Sahai. He's a prolific lawyer currently in the Supreme Court of India. Then there was Mr. Hakim Yasir Abbas. He is a professor in Srinagar University, and he's a terrific. He's a PhD holder, and he is teaching Constitution in Kashmir. And myself. So we three decided to start this mooting culture, and to encourage students to join moot courts more and more, or participate in moot courts more and more. We decided to touch upon the best of the moot courts. We did not know much, and one such experience I would tell you all is, we went for Stetson, and Stetson is an environmental law moot court. And it's really funny that we got the memorandums printed in a glossy piece of paper and all hardbound. In an environmental law moot, we used a glossy piece of paper. So the first round, when we were standing before the bench, and the first question that comes up to us is, "You do you believe in environment?" We say yes, Your Excellencies. Then the question that comes to us is, then why this glossy piece of paper? Are you not wasting paper? Why not a recycled paper? So that was one such question when I realized that, okay, this moot court is just not about what is there on the text. It is something which is also out of the box. So this is how my mooting journey began, and I personally believe that I grew as a mooter from my own efforts, and that with that I tried to encourage others and speak to our faculty. I mean, that was one of the most important things, because initial days, our law college would not be funding us while we would be traveling to different cities, and we used to take that pain of paying for our own tickets and travel to different cities and participate in moot courts. We used to figure out. We used to have. I don't know if it's still there or not, because it's been quite some time since I passed out. That time we used to have one thing called Mooting Premier League (MPL). I don't know,
It's not
Lakshmi.
there.
Yeah. So I think the current students, they would be able to tell us. So MPL, we used to constantly keep a watch which team is performing better, and there is no harm. There should be no shame in whenever you go for a moot court, and if you find a better team who is there against you, or who is there any better team which is participate in that moot court competition, go into the courtrooms, listen to them, try to grab a copy of their memorandums. They go through them, go through the research material, the compendiums, try and see how they work. Because I was thoroughly impressed when once we were so this was Stetson, and then in my final year of law school, I went for Willem Sevis Hong Kong rounds, and we were up against Stetson. So my mooting journey began with Stetson Environmental Law Moot, and my mooting journey got over with Stetson University's, the round which we were having with Stetson University, and we won that round. And I was amazed to see, although we won that round, but I was amazed to see the amount of research the people from Stetson had put into in that particular moot court. They had two flags, and while the speaker was speaking, so I constantly saw that the other team members would be banging a particular flag on the table on front of the speaker. So it intrigued me. Later on, we after winning that round, we became very good friends. In fact, on Facebook, we are still very connected. So I happened to ask them that, what was that? Why was the other team member banging that flag on the table? So then came the reply that this is how they had prepared. So the other team members were actually keeping an eye on the judges. If the judges looked too disinterested, they would put a red flag. If the judges looked very inclined and they're wanting to ask a question, they would put a yellow flag. So this is the kind of preparation that they had. So I was amazed to see, and this is, I think, with every small step, it's a learning experience in moot courts. Speak to the judges. You may lose a particular round. Speak to the judges. Get in touch with the judges, and that's how. One more name I would like to take in this is, when while doing my first moot court, I was being judged by a very renowned lawyer right now, Mr. Rishabh Sancheti. He's from NLU Jodhpur. You would know, Rashmi. I think you are from NLU Jodhpur. So Rishabh Sancheti was Rishabh sir was actually one of our judges, and after the rounds got over, we lost out. So after the rounds got over, I we went to we meet Mr. Sancheti, and now we meet in the Supreme Court premises quite frequently, and we asked him that how do you think that we should enhance our skills as a mooter? How do we bring in that mooting culture in the college? So he asked us to draft a constitution for the Moot Court Society and prepare different documents, have meetings regularly. And that's what we started to do. We went back to the college, we formed an MCS, we started having weekly meetings, bringing in more and more students to participate. We had a convener and the deputy convener appointed. And this is how we developed. So, all the students who are here, it's very important for them. And that's why I'm stressing on this question so much, that don't get bogged down. If your college is not having moot court society, if your college is not participating in moot courts, don't get bogged down. It's you who can take that initiative and take it forward from there. And be an example, lead by an example. I think it's very important to become a good leader. Right. Yes, Rashmi.
I can so relate with your answer
Yeah.
because, and I have also been in front of Mr. Rishabh Sancheti.
Okay.
He was an absolute terror in LA
Yeah,
Odisha.
yeah.
He always used to come for our internal moods.
Okay.
And absolutely, even I come
Oh,
from,
sorry, I'm so sorry. I thought you were from NLU Jodhpur.
no, no, I'm from NLU Odisha.
Okay, I have been to
So,
NLU Odisha as a
yeah.
judge. I had gone to judge one of your internal moods once,
Yes.
long back.
So I come from the 2012-17 batch. I'm the
Okay.
fourth batch of my college.
Okay.
So even, I mean, I wouldn't say that we didn't have a culture when I joined,
Hmm.
but the entire culture was because of my seniors. The way
Right.
they created that culture, they were
Hmm.
so passionate about it.
Yeah.
Like they did not need the administration or the college to do it for them. They were
Hmm.
more than happy to take the initiative. So
Hmm.
I completely second the advice that you have given to the students,
Hmm.
that it always comes down to taking a lead and leading by example. I mean, I would second you on that. And on that note, I would ask the second question,
Right.
which is, what kind of mentorship do you think is needed or required, and how necessary is it when you are preparing for a moot? So, for
Hmm.
example, seniors or teachers or any other person who can
Hmm.
be a mentor.
What kind of mentorship? I think it's very important to have a good guide, right? So, a teacher who helps in making the student, there we have stage fear, and moot courts. Although the audience, we are not facing the audience, but we are facing some fierce judges who are going to go through a barrage of questions and some territories which we have not never treaded into. So once, in fact, I would just slip into one more anecdote. One of my friends, he was in your college, in fact, in NLU Odisha. Uh, we were judging one of the internal moods, and something happened in his courtroom, and he said that, okay, then I'm granting you an adjournment. Why don't you seek an adjournment, like what happens in a courtroom? And this is, I think, 2015 August. That's when I went to judge one of your internal moods, and the student was completely taken aback because he never expected that question to ever come up. So, a mentor should be someone who would be very adept with all the court practices, whatever happens, because we often we end up choosing a wrong mentor, and that person, if he or she has not mooted in his life, so it would be difficult for a person. What I feel always, a person today, the young students who are there listening to me would become mentors tomorrow to their juniors. What all I learned as a mooter while I was doing Jessup was one of the study materials which we were given. It had a very important way of proceeding with a moot court, and it gave us the IRAC method. So IRAC means issue, I for issue, R for rule, A for rule, A for answer. A for application, and C for conclusion. And in fact, this IRAC method is something which is even valid even for a person who is preparing his code file. Even today, for me, I would always go into this IRAC method. That's something which I learned in back in 2009, 2010. So this IRSC method is basically we in a moot court competition. Since you have been a mooter yourself and you would agree to it, and there are young fellow students who must have started doing moot courts. We have given issues set issues given in a moot court competition. So we have an issue. Then after that issue, we need to apply the rule to that particular issue. So we need to identify what rules are applicable. So suppose if I am doing a moot court competition on real estate, on insolvency and bankruptcy code, so we know that IBC is going to be the rule that is to be applied. Now, once I apply that rule, how that rule is going to apply to my case, right? So application of that particular aspect of the law in relation to my case. So that is the most difficult part, applying that rule in your case, and that requires a lot of research, judicial proceedings. Once you have gone through that phase, then the conclusion. So this is I'm actually giving a mixed bag of everything because I know there is a shortage of time too. So what I feel a mentor should do is, first of all, make the student lose any kind of stage fear that the student may have, right? Once that stage is gone, then put a lot of effort and stress on the research work. What I have seen as a lawyer also in students who come to my office for internships is we have a very easy way of method of researching these days, of googling things. And I think it's a good way because my father never had Google. He's a lawyer, but he never had Google, and he had to go to the textbook. The difference between googling and going into a textbook for research is Google is very temporary, but your textbook research is very permanent. You would always remember what you have read in a textbook. So I would always encourage students to read. As a mentor, if they come to me for asking how to mentor them for a moot court, I would ask them to read maximum, allot maximum time to reading. And then, of course, the way a person researches and carries forward with the issues and everything, that's also the last step in preparing for a moot court.
I'm so glad. I mean, your mention of IRAC, it brought up so many memories for me. I mean, it's amazing. Anyway, so my next question is, and it's something that I wish I had known when I
Mhm.
first went for mooting, how to make how to form a team. I mean, because most of the students end up going for making teams with their friends, or oftentimes at the cost of being casual, oftentimes people they are dating also.
Mhm.
So, how to make sure that you are picking the perfect team, and what exactly is a perfect team?
Hmm.
What should be the combination strengths that we should be looking at when we are making a moot team for ourselves?
I'm actually wondering what would have happened if I made teams with my friends, because one of my friend was a very good tennis player and the other friend of mine was a very good footballer, and they were not into mooting. So I think we would have a good sporting moot court competition then. So don't bring in your relationships, your friends, your girlfriends, your boyfriends while preparing for your team. Never do that. If you really want to succeed in a moot court competition, then that's a big red flag from my end, because uh, you have to have a very healthy team to prepare for these tough competitions. There are teams complacent, who are very complacent. There are participants who would do that, and you will come across such teams during during the moot court competitions. But you would see their efforts. It's nothing. They have just gone there for a holiday. Holiday. That's it. So never get into this. Preparing a good team is actually, different colleges have different criterias. uh, as far as I know, all the senior most college students, they are usually allotted with Jesup any big moot like Stetson or a Jesup or a Philips Willem Civis. So that's one way of looking into it. And even if they in that stage, suppose a final year student is going for Jesup, even they may face a problem with regards to preparing making a team. So my only this thing understanding or advice to the young student, mooters right now would be that identify two very good speakers. Number one, And not only speakers, you will have the speakers will also have to be good researchers, because ultimately it is the speaker who is presenting the case, and if any question which is outside the box is being put forward to the speaker, he would have to face it and answer it quite ably enough. Apart from that, have a very good research team. You would need people who are very good with research, who are very good with operating these Westlaw and SEC Online and Manupatra search engines. And they should also be very very good with books. They should be able to sit in the library for long hours for research. A good team always is one which is always united. So never have conflicting people in your team, because that would always make your team a bit disoriented. So my suggestion would be, even if there are what happens is, we faced these kind of situations at times in a moot courts. There used to be two best speakers and they would have an ego clash. So because you will have to allot the issues amongst yourselves, and if a person is taking the issue of jurisdiction, because jurisdiction is a relatively tougher issue compared to merits, and if a person is taking an issue on merits, there would always be a conflict. So, as far as my case is concerned, I used to do a lot of moot courts with Yasir, one of the three names that I took in the beginning, very beginning, and we had very good camaraderie as far as preparing for moot court is concerned. I would always give him the jurisdictional issue, because he's right now a professor, so you can understand the amount of research he can put into but any particular issue, and I would always love to do merits. So we maintained that track throughout our mooting career, and that's where we also brought in researchers. We had observers. We had so when you are in a third year or fourth year, try to have first year, second year students as observers. Give them small research works, and give them an opportunity to attend the moot courts with you, so that when they reach the third and the fourth and fifth year, they are pretty prepared to tackle the pressure of bigger moot courts. Right. So I think this is a perfect combination that you need to have in a moot court competition, unless and until you are appearing for a moot court which is like a Willem Civis, because in Willem Civis the number of rounds are many, and plus you have the chance of getting an honorable mention. So there, what usually law schools do is, especially the Western law schools, that is, they have four speakers, two speaking on claimant side, two speaking on the respondent side. So this is how they divide the issues, and that also helps them in getting a better average score and getting an honorable mention in the final list of speakers. So unless and until you're going for a Willem Civis, where you need four good speakers, I would suggest having two good speakers is sufficient, as far as the Indian moots are concerned, or any other moot for that matter. You can have speakers, because the team limit, I don't know the current criteria for the team limit, because there were moot courts like Philippe C. Jessup during our times used to allow team composition up to 6 or 7, I think. So you can have a bigger team, more speakers, but all the speakers have to be good researchers. So you have to have a good combination, basically. Yeah.
There is a very interesting question by one of the students. I was going to finish up my questions,
Hmm.
but someone has written something which resonates so strongly with me. I'm going to put it up first.
Hmm.
So Navjot is saying that when once I was participating in Moot,
Hmm.
opponent team's speaker said the prayer two times and both have different words for prayer, but they still won. I think every single one of us can relate with this situation where in your head you are like, okay, that team was not good enough. And
Hmm.
you are just wondering as to why they won. I think we
Hmm.
have all been there.
Yeah.
So, do you think there are any specific factors or any such things which can actually make or break a win in a moot court competition? After so much experience that you have,
Mhm.
what would you say is your takeaway?
Uh, I think if I am sitting to judge a particular moot court, then or when I was personally participating as a mooter, if the judge is asking a lot of questions to you, then in my opinion, then you are doing well, because the judge is interested in your arguments. He or she wants to know more about your preparation. They are enjoying the grilling session. If the judge is not putting many questions, you understand that you are on the weaker side. So that is one way. I don't know if Navjot, you were asked more questions or not. I do not really know what went into the judge's mind while giving marking the scores in that particular round of yours. But personally, I feel that I would always not judge on the speaker's ability to shout in the courtroom. I have a loud voice, but that doesn't mean that everybody would have that kind of a voice. If Ram Jethmalani was a very forceful speaker, but then we had many such lawyers like Soli Sorabji. He was not a very forceful speaker. He used to be mild and very soft. So shouting before in the courtroom is not the criteria to become a good lawyer or a good mooter, but a good research is. So the ability for you to understand the questions, that is one of the criterias. The ability for you to listen, I think for we always misunderstand that a lawyer has to be a good speaker. I always say that a lawyer has to be a very good listener because you need to understand and listen to the judges. Also, one more thing, I have seen these traits in a lot of speakers. In fact, during our times also, these things used to happen. Whenever a judge puts a question or whenever a judge asks a question, the tendency to cut the judge in between and answer. Never do that. So these tendencies, often disappoints a judge. So he or she may get off track and may not give you good marks or may not be interested in your arguments if you cut the judge quite too often. And as far as the prayer is concerned, the question that was put forth, I think prayer is one of the most unheard part in a moot court competition. Nobody is interested to listen to the prayer because even the judges, after sitting for, say, 1 hour, because 30 minutes for one side, 30 minutes for the other side, and in my round, especially whenever I'm judging a moot court, there has never been an occasion that I have confined myself to the 30 minutes or the 1 hour that has been allotted to me. I have always overshot because I like to ask questions. I like to see the research skills, I like to see the skills of the speakers to take those questions. So I'm not very interested in listening to the prayer clause because it's all already there what they are praying for. I'm more interested in listening to their arguments for and against both. So maybe if the prayer was said twice, the judges didn't listen to the prayer. Maybe so. And but at the same time, Navjot, uh, don't feel disappointed. These things will happen, but these experiences will eventually shape you as a good lawyer. So moot courts, winning a moot court is a very short term gain, but becoming a good lawyer through these moot courts is a long term goal and long term gain. So target for that, and don't get disappointed or bogged down by losing a particular round or a moot court competition. These things happen. Yes.
Okay. My next question would be, and this is something I have been an academician for quite some time as well.
Right.
So, this is one question that I often come across with my students, and that is that they feel that participating in a moot court competition. So, for example, if we talk about something like Jessup, my own batchmates in final year of college, they literally gave away like 6 months just to prepare for it. So a lot of students have this feeling that, while preparing for such big competitions, they will be compromising their academics
Hmm.
while preparing for it. So what do you have to say on that front?
Oh, very interesting because if you ask me to give a very blunt answer, I think academics and all they don't matter much. It is eventually when you enter the courtroom, nobody is going to ask you what was the CGPA. But when you enter the courtroom and you appear for your matter, your mooting experience, your research skills that you had developed in the school, in your law school, would be helping you in presenting your case better before any court of jurisdiction. Before maybe it may be before the Supreme Court or the High Court or the Magistrates Court or the Sessions Court. That experience will count. So give importance to your academics. I'm not saying that completely ignore it. Uh, it's okay to be an average student. I got a CGP of 7.8, and I think I was very happy with it. I think more than happy because I was more inclined in moot courts. I was more inclined in sitting in ILI or ISIL. If people from Delhi who are not aware of ILI or ISIL, ILI is Internal Law Institute. They have a beautiful library. ISIL is Indian Society of International Law, which is again they have got a terrific library only concentrating on international law. So I used to love to sit there. There used to be a canteen, and it was being run by one Mukesh Bhaiya. I used to have the thalis there, and I am actually going back to my law school days and enjoy reading. So give yourself time to moot courts more, and yes, pay attention to your academics, but not much. And you can always, as a lawyer, also once you become a lawyer, while you're preparing for a moot court, you're preparing for one moot at a time. But as a lawyer, you would be put to a situation when you will be preparing for four different cases and four different subject matters on the very next day. So, balancing everything is very important, and learning that balancing act while you are still a law student. I think that's one of the things that moot court teaches you, because then you will have to balance your attendance, you'll have to balance your academics, your next semester exam, and your moot court, and you'll have to devote time according to the way you want to prepare for each and everything. Don't lose out on studies completely, but it's okay, it's fine to not get a CGP of 9 and settle at 7.8, 7.5, but at the same time participating in a moot court like Philippe C. Jessup. So it's absolutely fine. It's I think doing you world of good if you're able to maintain this kind of a record.
All right. I have another question after which I will be moving to the students' question. And
Yeah.
the question is, how would you see that all of this mooting experience, and of course, you have seen your batchmates, your junior, your seniors, who would be in law firms right now,
Mhm.
would be in judiciary, in different career aspects. How do you think having experience of mooting
Hmm.
affect your career prospect or your professional journey?
Hmm. Oh, it does. As I said, it's going to do a world of good to you, because moot court teaches you how to research, how to understand the keywords while you're researching, and you are definitely at a higher pedestal when you have been a good mooter, or not even good. You have been an experienced mooter for that matter. Good or bad is subjective, So if you have been an experienced mooter, as compared to a person who is not that experienced as a mooter or who has not done moot courts, you will definitely see yourself to be in a better position. Because as I said in the very beginning, moot courts, I feel, are tougher than a court case. Because in a court, you do not have a defined time period wherein you'll have to finish your arguments. You can seek for an adjournment. You can ask time to file a written submission. You can seek time for filing another application. Different things happen. So, but in a moot court, if you exceed 30 minutes, you will be given 5-10 minutes more, and after that, there will be negative marking. Negative marking will begin. So you have to confine your arguments. That lengthy 50-page problem will have to be confined in those 30 minutes. That too between two speakers. So 15 to one speaker and 15 to the other speaker. So I think doing moot courts as a lawyer, you will definitely end up gaining a lot. So it'll be helping you in becoming a good researcher. It'll be helping you in facing the judges in the courtroom, because it's always going to give you a platform to prepare for the big day when you appear before the court. Because you'll be grilled when once you do moot courts. As Rashmi, you would acknowledge this, that you have said that you were grilled by Mr. Sancheti. So you understand what grilling, what level of grilling that we have to undergo as a mooter. So once we have gone through that experience, that grind, once we appear before the courtroom, initially it looks like it's not a cakewalk, definitely not, because then you have a real life problem in front of you and you have to save your client, you have to defend your client. So that's separate pressure altogether. But definitely you will have that confidence in appearing before the judge, presenting your case, if you have done moot courts in your lifetime.
I absolutely second you on that one. I mean, I used to be that person. I used to love grilling. I mean, being grilled, and now I love grilling as well. I think it really, changes the extent to which you can think, because you come up with such innovative arguments that you never even thought of. So I completely agree with you on that. On that note, I will now switch to questions that are coming from our audience.
Sure.
Yashi, if you could help me with the same. All right. The first question is, can you please tell basic topics to research in mood code for a beginner?
So there are no basic topics, I would say, because there are different moot courts on different subject matters. For example, I think Rashmi Ledex is coming up with a wonderful moot court which is going to deal with these online gaming apps. Am I right?
Yes.
So this is a very new topic, and it's an amazing area of having a moot court competition on this kind of a topic, because we do not have too much of judicial precedence on this subject matter yet. It's still still a growing area. So there won't be any basic topic of research for as far as moot courts are concerned. I think you need to develop yourself as a good researcher. You need to identify which area of or which subject matter excites you the most. So if you want to go for international humanitarian law, then you have a Henry Dunant or a Philip C. Jessup. If you want to go for environmental law, then you have Stetson. You have trial advocacy. I don't know whether that moot court is still being continued or not by Surana and Surana. So Surana and Surana used to have this trial advocacy moot, which was based on cross-examination of witnesses and examination chief of witnesses, and then the final argument. So it was a completely different concept compared to other moot court competitions that used to happen then. Now LEDX has come with such a wonderful subject matter. So it is for you to start off with a particular subject matter, whichever area you like the most in the beginning. Never be repetitive. If you have done a moot court competition, say on environmental law, if you want to do Stetson, if you have targeted doing Stetson and getting to Florida once in your lifetime, then that's a different issue altogether. But never get repetitive with regard to other moot courts. Try and touch different subjects also. But as I said, if you have targeted a moot court, then give it 2 or 3 tries and then move on. So I think, sorry, I forgot the name of the student who asked me this question. Ritika, right? So Ritika, so I would rather suggest that I think you start spending time in the library. Start finding out about the moot court competitions, which all competitions are being held across the country. See the ones which actually excite you. There is one moot court on space law, Manfred Lux, and ISIL is one of the organizers of that moot court competition. So go for these areas, and also your choice of moot court should also help you in shaping up you as a lawyer. So if you want to go for an LLM tomorrow in international criminal law, then definitely go for a JESUP. You opt for something like JESUP. If you do not want to go for international criminal law, you don't want to go anywhere, but you want to stay in India and practice as a lawyer, then you can try for moot courts which specifically deal in domestic laws. So, like the trial advocacy, like the moot court which LEDX is going to do now. So there are different subject matters. So no specific subject matter I would ask you to, because you are still a young student. Don't confine yourself. I mean, be very open, be very accepting to different ideas and concepts in moot court.
All right. Can we have the next question? All right. We have moved in 15 days and all the team members are first timers. A memo was late to submission. How can we exercise maximum damage control in orals? I love this question.
Okay. That's a very good question. That because we always face these kind of situations. Maximum damage control during your oral rounds, I would say, uh, be very thorough with your whatever research you have done, because as I said, prepare a very good compendium. I think every corner you need to see and see in your written submission, since you have been late. So there must have been some negative marking to it. So don't keep any loopholes pending. If you see any gray area, try to get into, which I don't know which moot court are you doing. If it's on international law, try to get access to Westlaw and research on each and every subject matter. If there is something completely against you, try to find out the ways to rectify those damages. Try to find out judgments from different courts. If you do not have an ICJ citation, I'm just assuming if you are going for international law. Similarly, if it's for domestic law, try to see if there are judicial precedences by different high courts or the Supreme Court, and try to that's how the damage control will happen. And as far as the speakers are concerned, I think start grilling yourself. I mean, be the biggest critique of yourself, and have good team sessions, practice sessions. But the speakers should constantly give at least 3 to 4 hours a day, because you don't have much time left now. So at least 3 to 4 hours a day, wherein all sorts of questions that can occur in your mind pertaining to the moot court should be put across to the researcher, to the speakers, and at the least amount of time, you should give allot the speakers and try to make them finish the submissions. You will have faculty who would be helping the moot court society. Make the faculty sit and take those rounds. Try to confine, because you ask them to grill you all as much as possible, because make a real courtroom moot court scene happen in your practice sessions. So the more you practice that way, the more pinpoint your answers would become. So that way you would definitely reduce the time taken while you're arguing your case, so that you do not overshoot your time while the oral rounds happen. Try to grill, make your faculty members sit as judges, grill you as much as possible, so that you know how to tackle these questions and take the least amount of time. First 2 3 sessions you will definitely going to overshoot the time period, but that's how by the time you reach the 14th or the 15th day before the moot court, you will be definitely a better speaker, and you'll be better with your time management.
Next.
Yes.
We do not have any mooting on regular base. It would be a great help to know about from where, Yashi, I think, from where we can regularly practice mooting.
uh, I do not know if there are any online or any such institute which conduct such specifically mooting classes or not, because we did not have any kind of setup as such during our times, during my college days. So, if you do not have a mooting culture, like I said in the very beginning, start a mooting culture in your college. I know it's difficult. You will have to tread into a complete new territory, but influence or convince your faculty to help you out, and find out moot courts, because you are starters. So find out moot courts which are not so difficult in terms of scale, and start going for those. In I don't know, again, the student, I think it was written Haryana, so I'm assuming the student is from Haryana. So if try and find out moot courts in the Delhi NCR region, and try and opt for those moot courts, participate in them. So and I think you can reach out to me on LinkedIn. If I can be of any help to any of the mooters, not only the person who asked this question, because I know what it feels like once you appear in a moot court stage and you are not well prepared, or your college is not supporting you. So from my end, any unconditional support, I would definitely be there to help out these young mooters. So you may reach out to me on LinkedIn, and I'll definitely be able to help you out. My library is there. If you want to research, you can definitely have access in my library in Delhi. So that I can definitely help you in.
That is very kind of you. I'm sure many students will want to take up that offer. Can we have the next question, Yashi? Thank you. What are the three most important things that a speaker should know before starting his or her moot?
Three most important things. The three most important things is good listening, and good listening. That's it. You have to be a good listener. Very beginning, I said, if you are a speaker, you will see. You cannot have the stage fear completely gone from the very first day you have started mooting. Even the best of the lawyers, they are nervous, and I feel that it's very important to be nervous, because nervousness actually brings in that best in you. A person who is overconfident is a risky proposition for me, but a person who is nervous will prepare till the last moment. So any speaker who says that I'm not nervous is actually bluffing, and he's trying to play mind games with the other speakers. So it is good to be nervous, and apart from that, you have to be a very good listener, because you may just stand up in the courtroom and hurry on with your submissions and finish your arguments in a jiffy. But once the judges ask you a question, that's when your actual mooting begins. Because almost everyone, they know what is to research, and to what extent the research has to be done. That is the question. So, for example, a student does research up till point Y and does not touch Z, but a student who has done the research up till point Z will be better prepared, and that better preparation can only come up when the judges ask questions. So you will have to be a very good listener for that reason. So if you are a speaker in a moot court competition, uh, try to have practice sessions wherein uh, at a time there are two three different questions being put forth by different judges, and how you tackle that pressure, because that do happen, because once you finish answering one question, your mind has still not relaxed and you are put forth with another question. So these occasions will happen for a mooter. So try to practice these kind of adversarial situations when you will be given 3 4 questions at a go, and that's how you can prepare and enhance your listening capabilities. So I think good listening is the most important criteria for a good speaker in a moot court competition.
That's a wonderful answer. To be honest, I would like to add from my end on this that, like what Chen said, that if you are a good listener, in my own personal experience, rebuttals can be a truly breaking point for a moot court competition. They used to be my favorite part as a speaker. So if you are listening very well to the arguments of your opponent, you can make extremely good rebuttals, and that really counts
Correct.
in your performance in a moot court competition.
Right.
Yashi, if I could have the next question, please. What are the documents that are usually prepared before any moot court session?
So before, I think before any moot court session, before the oral rounds, definitely you'll have to submit a memorandum, written memorandum, which is to be submitted to the judges, and you are judged for that only at the stage of prelims. Beyond the prelims, only the oral submissions count, and that's precisely with almost all the moot court competitions. I think very few cases happen, very few situations happen wherein there is a tie in the scores, and then the memorandum scores are taken into account. Otherwise, it is usually till the prelims, and that's basically the requirement for making your submissions in the competition. Apart from that, you need to have this is something which you'll have to submit to the competition in the competition. Apart from that, you need to have a compendium. That is, compendium should contain all the research materials, the law that you are referring to. I think it's always advisable to have two compendiums. One which is a compilation of all the statutes, all the laws that you are referring to. One compendium should only contain the judgments. So have a proper indexing done of these judgments which you are citing, and this is something which you will be coming across as a lawyer when you start practicing in the courtrooms, because now also we do submit a compendium or list of judgments before the courts. We file them before the courts. We do a proper indexing, page numbering, so that the judges, these small things impress the judges a lot. So if you have a proper pagination done, and you can give the copy to the judges before making your submissions, these small body language and the small gestures that you can show to the judges, these are going to. There are occasions when both the teams are very good, but one team is very arrogant and they may lose out, but the other team is very humble. They have that court manner, the court decorum, the etiquettes to present the case before the court. Uh, so you practice all these small issues. So documents, you should always carry whatever documents you research. Very shoddy, if you have a lot of documents on the table and all messed up, it doesn't look good. So that's why I said always prepare compendiums. Apart from that, the research material during the course of your research, try to compile that also into a sort of a compendium. Don't give it to the judges, but keep it to yourself. The notes that you have made, have flags made into it. So put into that compendium so that you can refer to it whenever required. So I think these are the documents I think you would require as a mooter before the oral rounds.
Thank you. Yashi, can we have the next question? Could you please shed some light upon the importance of mood for a judiciary aspirant? Good question.
Well, that's a good question. I think a judiciary aspirant, for any aspirant for that matter, judiciary, or if you want to go into the civil services, or if you want to continue with litigation, mooting is definitely, see, if you are a judiciary aspirant, then definitely you would be doing a lot of studying has to be much more. You have to go through another grind. After clearing your AIB, you'll have to sit for few more examinations to clear the judiciary, right? So as a mooter, once you start mooting and you take that pressure of researching, so that will always anyway, that will in any case to analyze a particular case. There are situations, there are cases in which one side is completely very heavy, the other side is complete, it's on the downside. But to research for that side which is weak, which looks weak on paper, and bring that side or lift that side of that particular party before the courtroom, that's the art. That's the art which you need to understand, which you need to do. I think, and this is personally, I would say that many a times it used to happen that I would feel that the merits on for the respondent or for the claimant is very weak. But after the research was over, I would realize, no, we are much more heavier than the other party. So these things do happen. So I think for judiciary also, the research that you would do as a moot court as a mooter, plus the research that you would be putting forth across before the judges, these things will definitely help you in the long run. So once you prepare for your judiciary, you would be able to recall, okay, this is what was written in the ICJ statute, or these are the treaty conventions that I remember because I have prepared these things in my moot court days. So you will be there. There are different subjects in judiciary. So definitely, these reports will definitely going to they are definitely going to help you in the long run.
Yashi, next question. Being a debater with a very good victory conversion and a speaker with an aggressive stance when in context with moods,
Hmm.
how bullhorn should I be in my deliverance or how much should I hold back? I can relate.
No, don't hold back. It's- as I said, don't hold back. That's your natural self. Don't change your natural self to something which you are not into, right? So I gave you two examples of Ram Jethmalani, who was a very forceful speaker, and Soli Sorabji, who was a very mild and soft-spoken lawyer. So and both were great lawyers. We have no doubts about it. So both were legal luminaries. So both they both had the different ways of dealing with situations. And I am a forceful speaker. I love to argue forcefully before the court. I admire the way Mukul Rohatgi argues before the courtrooms. So that's something which I love doing. So I can't change myself into mild speaker. So but there is a but in this. Once you get enter into this profession, there would be some occasions wherein, since I also I have a heavy criminal practice, so there would be situations when you are seeking for bail and the court is completely against you. You would definitely have to soften your stand a bit to ultimately get relief for your client. So these situations will happen, but that you learn with experience. But don't change yourself. Be an aggressive speaker. If you are an aggressive speaker, be if you are Virat Kohli, be Virat Kohli. Don't try to be MS Dhoni. So you have different styles. So
I love that analogy. It's so perfect. Yashi, is there any other question that we have that you want to put up at this point? We have already taken this question. Can we
yes.
move on? From which library we should start our research work, either our college library or something else?
If your library college library has a good database or a good good amount of books that you can refer to, then that's the way to from there you can start. You can also come down on weekends to ILI and ISIL, that they are in Bhagwan Das Road, right opposite Supreme Court. So you can always have access to those libraries. I do not know the current situation, because earlier we used to just show the iCards and we were allowed access to those libraries for preparing for a moot courts. I seriously do not have any idea currently what the students have to do to enter those libraries now, but I think they would allow. So you can always have access to these two other libraries apart from your college library. If you find that your college library is not that detailed, and they are lacking with the number of books, then definitely come to ILI or ISIL to research. You can always access these libraries.
All right. I would ask you a tiny question in
Yeah.
addition to this one.
Yes.
That is, so for the students who do not really have access to sources like Manupatra or SCC online, what is the alternative for them? Because many of the colleges do not have access to such
Mhm.
resources.
See, if you do not have such resources, then I would again suggest you that you travel to Bhagwan Das Road, ISI, they would be helping you out with Westlaw, Manupatra, SEC, and you have to pay a very small amount of money. Write down all the propositions that you need to research in. So during our times, they used to charge on an hourly basis. So we would come down, we sit for a couple of hours and quickly do all the propositions we used to research. Of course, you will be having seniors or elders who would be there in the profession, and they have access to all these search engines. You can seek help from them, and apart from that, also push your college. I mean, I think become a leader and fight and ask your college to take these subscriptions, because ultimately, if you win laurels for your college, it's a college's name that's going to go up, and apart from your name definitely will be going up. But we don't identify that X speaker won this moot court competition, but we say that this law school won the Philippe C. Jessup. This law school went on to win the Stetson. So we don't remember the speakers. Ultimately, it's a college's name that is always remembered. So tell this to your professors, tell this to your director. I think definitely they'll be convinced. And this is probably to all the students who are facing this issue. The art of a lawyer is to convince. Start convincing your faculty and your management to what you want, and that's the first test you have as a lawyer before you.
Thank you. That is spoken like a very evident former batch student. So that's very relatable. It's already 7:35, so I will not take much of your time afterwards. Although we do have a couple of questions after this, quite a couple actually. The students have a lot of questions to ask about mooting.
Mhm,
But unfortunately, we have run out of time for today's session. We have already crossed the 1 hour threshold.
mhm,
At this time, I would want to give this opportunity to this student that we do have extended master classes planned on moot court training for the 3 days from 25th of March to 26th and 27th of March. And it will be 6 hours long session completely about me mooting with people like Chen, who will be joining us, who have participated in various international and moot court competitions and will be covering each and every aspect of mooting, that is research, formatting, drafting, oral speaking, court mannerism, and all the aspects. So, all the students whose questions I have unfortunately not been able to pose to Chen today, I'm hopeful that you all would be joining us for those sessions as well.
Rashmi, I have a very interesting question. Sorry to
Yes,
cut in between. I have a very interesting question by one Ruchita Sharma, and she
yes.
wants to know: have you ever been anxious or fumbled while arguing, and how to get over it if anyone does fumble or is anxious over the before the judge? I think Ruchita, yes. I think anybody who is well prepared and who wants to give that extra effort will fumble, will be anxious, will be nervous, and it's absolutely fine if you are fumbled, if you are nervous or you are anxious. If ever it happens that you have fumbled and you have fumbled very badly before the judge, just calm yourself down. I think I wanted to just answer this question quickly. Just calm yourself down and say that okay, it's okay. Close your eyes, take a deep breath, get back to it. The judges are also human beings. They have also been ex-mooters. They have also faced these situations. They will understand you. Till the time you are there in the competition, that is more important.
Absolutely, I can also attest to that. So, on that note, thank you so much, Chen. I would
My
first like
pleasure,
to
Rashmi.
extend
My
my
pleasure.
gratitude to you for giving out your invaluable time to us, and it was great interacting with you. It was so much fun
Same here.
for me personally, and I'm sure the students have got to learn a lot. So, thank you so much to all the students as well who have attended this session, and I hope to have you all with us for all the further sessions as well. Thank you so much, Chen.
Thank you so much,
And
Rashmi. Thank you so much
good
for
night,
having me.
everyone.
Yes. Thank you, students. Thank you for listening to me. Thank you. How do I log out, Rashmi? Can you just
You
help?
can just close the session.
Okay, let's just close it. Thank you. Thank you so much.
Yeah.